So we're going to go ahead and start our afternoon sessions. The webinars are going to be about intellectual property. We're going to start with our presenter, Tina Peak. She's the Director of Library and Historical Resources for the City of Lake Wales and a member of our steering committee. And after Tina's done, we're going to switch up to Tallahassee to hear from Lauren Numbers to talk about the subject from the museum point of view. So Tina, I say go right ahead.
Okay, thank you, Robin, and thanks for asking me to do this. Just by a little bit of background, I have 35 years of experience as a public library director here in Lake Wales. With that said, I'm not a copyright expert, but I've had a lot of OJT and have experienced issues that I hope will maybe help you avoid some pitfalls in the world of copyright and libraries. We can begin with a definition of what intellectual property is. We're probably all pretty certain on this, but intellectual property such as an idea, an invention, or a process that derives from the work of the mind or intellect. It also is an application, right, or registration relating to these. Some examples that are a little outside the box on intellectual property, but all the same are intellectual property, could be an original recipe. This would pertain to if I concocted something or if a famous chef did. Scientific discoveries fall under the category of intellectual properties. Choreographical programs that are created by an individual or a group of individuals that are unique. Musical compositions, and most recently, I think we all deal with digital creations, which has thrown a whole new monkey wrench into intellectual property and copyright issues in libraries. What is copyright? Copyright actually, in a nutshell, protects intellectual property. It's the exclusive or legal right to reproduce, publish, sell, or distribute the matter and form of something such as a literary, musical, or artistic work. The U.S. Copyright Act protects intellectual property rights of published works, unpublished books, studies, drawings, maps, artworks, journals, diaries, music, and much more, including digital content. The framers of the United States Constitution understood that in order to foster creativity among their people, copyright must delicately balance between three groups. The first being the creator, the author, the composer, or the person who parented a creation or an intellectual property. And also balancing the content creator between their publisher. If an individual or a group of individuals is lucky enough to have their intellectual property come up for someone wants to buy it and produce it. This is the business side, the organization or entity that has paid the creator for the rights to their works in order to profit from the dissemination through publishing, film production, musical composition, etc. Their interest is more profit driven, but there's nothing wrong with protecting the right to earn an income from something you have paid for. And the final group, which most of us deal with in the library world, is the end user or the consumer. This is balancing the right of the reader, scholar, researcher to use or enjoy intellectual properties of the creator and the publisher without allowing plagiarism or other misuse of published or unpublished items. In the world of librarianship, we kind of act as an equalizer between those three entities. For example, we can give advice to a teacher who may want to show a movie in their class, and if we're aware that what they have chosen to show is outside of the parameters of a copyright, we can advise them against it. We have the responsibility to educate library patrons, students, researchers, and teachers, and most important, other library staff, paraprofessionals or professionals, what the U.S. copyright law states about the rights of the creator, the publisher, and the end user. What we focus on mainly is fair use. The end user has the right to use copyrighted materials within the confines of fair use. And very simply stated, fair use is private study, scholarship, or research. It is not taking a stitchery pattern book off of a library shelf and making copies and taking them to the flea market to sell as their own work, as we have had people do in the past. So we have to stay diligent if we're aware that someone is putting their toes up against the line of the copyright law. The copyright law in the United States has evolved many times over. The last time it was changed or updated was in 1998. It's almost 20 years old now, but you can see the breakdown in what that 1998, that's a lot of N's, what the final entity or the parameters we now deal with. In my own collection, we have an extensive collection of maps and drawings by a gentleman named Alan Carlton Nidegger. Alan Carlton Nidegger was the young civil engineer who came to this Central Florida area before it was divided up into cities and roads and building lots, and actually did that. He donated his papers, and along with that, he donated the rights for this library to publish them. Had he not done so, most of his works that we have in our collection range between 1905 to 1915. We do hold those rights, but even if we didn't, at this point, these maps are in the public domain. We trust they're up on Content DM under our Content DM site, and we trust that if it's used by a scholar or anyone, they would give credit to the library as the holding institution. But there's nothing to say that an individual can't just go online and make digital copies of those maps and sell them for their own profit, because they're now in public domain. The second step is published works between 23 and 63. You can see those parameters. This took a little bit of story problem math to figure these out, but an example of that is in 1923, Felix Salten published his children's book, Bambi. And by my calculations, it should go into public domain in 2019. The copyright ends in 2018. So whoever holds those copyrights now will no longer receive royalties at that point. 64 to 78, an example of that would be Ian Fleming's You Only Live Twice, and the copyright holder retains the rights of that book through 2059. I wanted to give you an example of someone who falls under that category, that last category, and I thought of Dr. Elie Wiesel, who was the Nobel Peace Prize winner and wrote the classic book called Night, that was a fictionalized account of his time in Auschwitz. Dr. Wiesel died in 2016, so the owners or the holders of the copyright for Night will hold that copyright until 2086, and at that point it would go into the public domain. So that's just kind of a rundown on the 1998 revisions. It's very important in libraries, in archives, anyone who has public access, photocopiers, scanners, anything that the public is allowed to use to make copies of copyrighted works, that this notice be posted. And you can read this. The key sentence in this one Section 107 of the copyright law is the person using this equipment is liable for any infringements. The institution reserves the right to refuse copyright if, in its judgment, fulfillment of the order would involve violation of the copyright law. It's very important that in my library that the end user presses that green button that says start. I don't mind if my staff help them line it up or get it straightened out, but the person who is using the equipment is liable for the infringements. And with the massive availability of materials on the internet, diligence in educating the users and staff and volunteers of what fair use is in the digital age is very, very important. Just because it's online doesn't mean every use qualifies as fair use. Library users, as I just said, should photocopy or scan copyrighted materials on their own. This shifts the liability from staff to the user. This would apply in an archive or anywhere that you are handling someone else's intellectual property that the public would like a copy of. If a library staff member makes copies or scans for the patron, the liability has been shifted back to the library, and in some cases, that staff member. Public copiers, scanners, and microfilm machines and other publicly used digital devices, again, should have that copyright statement posted to it. Collections and policies should address copyright. When you guys are writing your collection plan at the end, you do need to include copyright and the policies that you want to make sure are in there. Your collection policy can include and should include a right of refusal statement. You do have the right to refuse photocopies, scans, or access to materials based on your knowledge of the material's copyright status and what the end implication can be. I would encourage everybody to have a user waiver form in your statement or your policy. I looked up a user waiver form, and it basically says that you have the individual, the scholar, the researcher, sign to say that there is some question about whether this material, that they understand there is questions regarding this material's copyright status, and that you recommend that they reach out to the holder of the copyright and ask permission, and they sign that they understand this. If they go ahead and make the copy, do the copies anyway, then you've covered that. So those two things I think are very important: right of refusal and user waiver form. And then keep both on or keep your user waiver forms on file. Copyright concerns for libraries. It's very important to rely on the information you've gathered through the deed of gift or donor statement to determine the status, and include this in your cataloging record. Restrictions on unpublished works, including diaries, journals, letters, are addressed in that copyright law revisions 1998. That's a good place to look back and have an access to point to see if you're within those realms. For a public library such as myself and an academic library, materials you purchase, books, materials, movies, so forth, the copyrights are pretty standard. I'll get into film a little later, but the new monkey wrench in the library world came along when we started checking out VHS tapes, and you know, that put a whole new regularly part of our collection, regularly used part of our collection, in a different light. We had never checked out movies until the advent of the home video machine. So, but those are all things that we do need to be very aware of. Your institution does not hold the copyright to an entire donated collection unless the writer, creator, or publisher has conveyed that copyright to your institution or has been deceased 70 or more years. Family members cannot convey copyright. If somebody comes in with a great collection and says, these were my dad's papers, you still have the burden of who owns what is still on you, because unless that intellectual property was passed on to the heirs, they cannot just give away that information. And again, educate your staff and volunteers on the difference between physically owning something in a library and holding the copyright. This is a monkey wrench, again, that's been thrown in. A lot of libraries and now museums and in some cases archives are holding public performances. This is something I think probably libraries have done longer than anyone, and there is an onus on us to still have our eye on what the copyright law says. A lot of libraries, and ours included, show movies. We have musical performances. We, in some cases, have poetry readings or drama performances. The key here is if you're showing a movie, it must be a public performance right copy that your institution has purchased, or a blanket public performance license. We have a public performance license that covers many of the most popular production companies, but not all. and we pay around $400 a year, but there are even restrictions on that. That does not include, we have no right to show the movie outdoors. We have no right to show the movie off-site under that blanket license. It's very locked down to, you may show a Disney movie in the walls of the Lake Wales Public Library. And a public performance right copy of a movie costs about 3 times more than just a non-public performance. So that's kind of a key there. And if you have entertainers that come into your institutions, or just anyone to do a special program, make sure that the onus of the copyright is on them. If they are reading someone's poetry or performing someone's music, one hopes that they would be paying the royalties for that right. I wanted to mention before I wrap up that no political statement is being made here. I'm going to say that disclaimer up front. But there seems to be an effort to remove the U.S. Copyright Office from the Library of Congress. In this February, U.S. Representative Tom Marino, a Republican from Pennsylvania, reintroduced a bill that he had already introduced once before, that would move the Office of Copyright from the Library of Congress, which it has been since Mr. Jefferson was the first librarian, to the legislative branch of the United States government. And through the Library of Congress's policies, we have collected a robust archive of our culture and our scholarship. Over 162 million items are open to all. This is one thing that libraries, our content is free and open to all without judgment. If you want to walk into my library and check out an item that may be politically unpopular or socially unpopular, you go right ahead and do so. We are every man's university, every woman's university, and every child's university. The concerning thing with moving the Copyright Office from the Library of Congress to a legislative branch is that is not the case. I think most of us would agree that the partisanship and all, it's very concerning and kind of frightening to me that this institution that's run very well forever, now we're kind of talking about switching it up. I read about this in this month's issue of American Libraries, which is online. If any of you are interested, I would encourage you to educate yourself on that. And then finally, in summation, take nothing for granted when it comes to copyright law, and always err on the side of caution. I would really rather have a third grade teacher angry at me because I said you cannot just show Snow White and the Seven Dwarfs at 1 o'clock on Friday afternoon because you've had a long week. You really must have it in your lesson plans that you are studying dwarfs or Snow White or fairy tales or something, than to have that person subjected to the possibility of a lawsuit from Disney. And even though we all live in Florida, Disney is one of the most litigious, most active in protecting their copyrights. And not only will they sue institutions, they will sue the individual who has violated that. Educate your staff and volunteers, very important. And for super difficult questions, seek legal counsel. I've never had to do that, and I would venture to guess that there is no copyright lawyer in Lake Wales, Florida, so it would have to go outside of this area. But if it were a discussion about who owns something that's in my collection, I certainly would. Ownership does not automatically include copyright, and always remember that a library and archive, wherever it is your responsibility to balance the interest of the three groups: the creator, the publisher, and the user. And thank you very much, Robin and everyone. It's been a pleasure to do this for you.
Thank you, Tina. That was great. Thanks so much. This is our next presenter, Laura Nemmers. She's going to be talking about intellectual property from the museum point of view.
Intellectual property, what is it? Intellectual property is chiefly law properties such as patents, trademarks, and copyright material, which is the product of invention or creativity. Intellectual property refers to the products of human intelligence that are unique and have potential commercial value, such as ideas, inventions, designs, literary works, unique names, industrial processes, computer games, and programs. Overall, there are 4 categories of intellectual property: copyright, trademark, patent, and trade secrets. Copyright protects original works that exist in a tangible form. This includes literary works and publications, works of art, and architectural works. The laws of copyright protect these objects for a specific period of time from being copied, distributed, and displayed. A work does not have to be registered with the Copyright Office to be protected, but it can help the creator's argument in a court of law. Copyright law varies from country to country. A work that is not protected by copyright is in the public domain. These are works that can be freely used. This includes works published or created before 1923, works in which the copyright terms have expired, works in which the author failed to satisfy the required formalities for copyright, or if the work is a product of the US government, which I'll talk about a little bit later. This is a simple chart to help you identify if works are in the public domain. In my previous career at an art museum, we generally assign the public domain status to anything created before January 1st, 1923. Trademarks are protected as being intellectual property. Trademarks include symbols, phrases, and distinctive words that distinguish specific goods and services. The laws regarding trademark vary from country to country. I don't think I really need to explain trademarks to you, as I'm sure that you recognize at least 1 or 2 of them here. Patent law protects inventions, processes, and chemical compositions. This law gives the holder of the patent the right to stop others from creating, selling, or using their designs and products without permission. Trade secrets are secrets that can be competitive in the marketplace. This could include special formulas like Bush's baked beans recipe, Coca-Cola's secret formula, or Kentucky Fried Chicken's 11 herbs and spices. These are unique, developed devices or special programs. So now that we've defined the 4 categories of intellectual property, what do museums work with that might be impacted by intellectual copyright laws? Number 1, copyright. In an art museum, they often manage copyright materials every day. This includes, but is not limited to, educational materials, multimedia works, images of objects in the collection, images created by a professional photographer or publication. Yes, their photograph is also copyrighted. The museum's website and publications. Some museums have entire departments to manage the influx of copyright needs and requests. In small museums, that responsibility often falls to the collections or marketing and public relations department. Trademark. Your museum logo, the title of your exhibitions, catalogs and publications, the name of your institution, special educational programs, and slogans are all areas in which trademark law can impact and protect your museum. Patents. Museums can patent original designs or processes. This includes exhibition fabrication techniques and hardware, exhibition setups, processes for research and design. Trade secrets. Museums can have specific plans and ideas that are considered trade secrets that they don't share with others. These may include things like imaging techniques, business ventures, internally written computer programs, marketing plans and strategies, and also donor lists. In an art museum, copyright is the form of intellectual property that they usually deal with the most. So I want to go into more detail in regards to copyright, specifically copyright and fair use. So what exactly does copyright law do? It gives the owner of the intellectual property, in our case, the artist or author, the intellectual control over their property, as in adaptation as a derivative of the work. Examples of this include the Obama poster at the top right. The Associated Press filed suit against artist Shepard Fairey for copyright infringement, as he used a photojournalist photo to make the image on the poster. He said the photo portrays fact, so therefore it is fair use. The party settled out of court. If it had went to court, it is likely that it wouldn't be considered fair use, as he was using the image to make money. The sculpture by Jeff Koons on the bottom from 1988 was in an exhibition in New York. Jeff Koons commissioned the work by sending in a postcard he found by Art Rogers to his fabricator. The only differences between the postcard image and the sculpture are that the work is in color and that the puppy noses are exaggerated. As you can see, they're painted. Koons said the work was a parody and therefore it was fair use. The court ruled against him as there was no public awareness or message about the artwork. There was a financial settlement, and Koons also had to send the unsold sculpture to Art Rogers as part of the settlement. Lastly, the appropriated photos of Sherry Levine from 1981, shown here in the center. These controversial works by Levine are direct copies of photographs by Walker Evans depicting poor Alabama sharecroppers that he took in 1936 while he was working for the United States government. Levine rephotographed them as if they were her own. There really wasn't a basis to take her to court for the direct copying, as they were created while Evans was working for the US government. But believing her photographs to be copyright infringement, the estate of Walker Evans bought the entire collection to prevent anyone else from ever doing it again. Reproduction, I don't really have to explain that, that's just copying the work. And distribution is as in to make a work available to the public by sale, rental, lease, or lending. Performance or display, as in a film, slide, play, or dance recital, as Tina was talking about. And exhibition. As noted in the UCLA Law Review in regards to exhibition, infringement does not occur where a work of art is displayed without an accompanying offer to sell if care is taken to deter copying. As a museum, we're not selling the work on display. Thus, the exhibition of a work of art by a museum does not amount to infringement when public is admitted to view the work with the understanding that no copying will take place and that these restrictions will be enforced by the museum. So I've mentioned the term fair use a few times now, but what exactly is fair use? Fair use is a mechanism that allows for an exception to the general rules regarding the exclusive rights of copyright holders. Under the fair use doctrine, copying for the purpose of criticism, comment, news reporting, teaching, scholarship, or research is permissible. In addition, copying or photographing a work for internal registration or archival purposes is permitted. This sounds awesome, but how is it really determined? This chart from LaGrange College Lewis Library shows some considerations you should take to determine if you think something might be fair use. The problem with fair use is that it is not always clear. There is no specific number of words, lines, or notes that may safely be taken without permission. Acknowledging the source of the copyrighted material does not substitute for obtaining permission. Often, if taken to court, it will depend on the judge as to whether or not it is fair use. The best course of action, in my opinion, is to always get permission from the copyright holder, especially if there is doubt. When possible, and if there are no other options, avoid using questionable or copyrighted materials altogether. It's often easier to find a substitute. If you do have questions or doubt, you can always seek the advice of an attorney. The bottom line is cover yourself. Court decisions do not form an altogether coherent pattern. There are often inconsistencies in assessing whether a work is indeed transformative. The idea of fair use and adaptation can be seen in these examples, which demonstrate the slippery slope of the fair use doctrine. While transformative aspects of a new work often weighs in favor of fair use, various court decisions can be made depending on the judge, and it is really unclear. As I said before, there are often inconsistencies in assessing whether a work is indeed transformative. In this case, the Ninth Circuit rejected the fair use defense, saying that it was not transformative and commercial to use the well-known Cat in the Hat poem of Dr. Seuss as the basis for the fully rewritten poem telling the story of the O.J. Simpson criminal trial. The Ninth Circuit Court of Appeals determined that the book was a satire, not a parody, because the book did not poke fun at or ridicule Dr. Seuss. Instead, it merely used the Dr. Seuss characters and style to tell the story of the murder. So, in this case, not fair use. On the other hand, the Second Circuit Court held transformative and fair a photograph combining the head of middle-aged actor Leslie Nielsen with a nude pregnant female body meant to duplicate the Annie Leibovitz cover photo of Demi Moore for Vanity Fair magazine from 1991. The Paramount photo was a parody that employed similar lighting and body positioning that served as a promotional poster for the film The Naked Gun 33½. The court found that although Paramount's photographer drew heavily from Leibovitz's composition, the parodic purpose and absence of market harm made the work fall under the fair use doctrine. While Leibovitz had argued that she was entitled to licensing revenue from the photograph, the court found that the parodies were likely to generate little or no licensing revenue. The court took particular note that while the composition and posing of the models is the same, other elements such as lighting, color contrast, and the larger ring on Mr. Nielsen's hand and his facial expressions are different. So this one was considered fair use. Did you know that just because you own it, even if you bought it, you don't own the copyright? Copyright always stays with the creator. So unless they give the copyright to your institution, the rights of the creator are protected. This comes as a surprise to many people. I am very briefly going to discuss in this presentation the Visual Artists' Rights Act of 1990, also known as VARA. The Visual Artists Act provides protection to artwork created for exhibition. It grants the artist the right to claim authorship, to prevent the use of one's name on any work the author did not create, to prevent use of one's name on any work that has been distorted, mutilated, or modified in a way that would be prejudicial to the author's honor or reputation, to prevent distortion, mutilation, or modification that would prejudice the author's honor or reputation. Additionally, authors of the work, recognized stature, may prohibit intentional or grossly negligent destruction of the work. To date, recognized stature has managed to elude a precise definition. An example based on VARA is that of the mural in Los Angeles painted by the artist Ken Twitchell. The Ed Ruscha monument was painted over in 2006 and was quickly followed by public outcry. Twitchell then filed lawsuit under VARA for painting over his work without permission. Twitchell won a settlement under VARA against the US government and 12 defendants for $1.1 million. So why do we as museums have to worry about copyright? I'm not sure that I realized when I got into this field that I would deal with copyright as often as I do. A few things related to copyright that I managed regularly at my previous job were non-exclusive copyright for the permanent collection, which was obtaining permission from the artist or rights holders for image use for things such as educational purposes, brochures, web, social media, media events, and exhibition announcements. The non-exclusive copyright agreement that we had did not cover commercial purposes such as postcards, posters, stationery, and the like. Those requests would be negotiated separately. Online expectations. These days, the general population expects most, if not all, collections to be online. The question is, and this is up to the institution, do I seek copyright, hope that it is fair use, or just take the risk? Many museums who have images online utilize a watermark, as you can see here on the painting by Robert Blockme, the woodcutter on the lower right side of the image to protect the copyright. Museums, particularly small and medium museums, are underfunded and often understaffed and struggling to stay relevant. Staying relevant means incorporating our collections online on our website through social media and through interactive exhibitions that may include technology such as iPads, surface tables, and videos. Visitors. The use of cell phones as cameras has been a particularly hot topic of conversations at museums in the past few years. Who is taking the pictures? What will they be used for? Do we have permission from the lenders? How will the artists feel about the visitors taking these photographs? Museums, particularly art museums, are used to having control over their images and how they are used and distributed. And the adaptation to the digital age is a difficult one that often seems to follow the hope for forgiveness policy. With so much technology, it really is almost impossible to manage visitors' interactions with technology in the collection. So that is a lot about intellectual property. So now how can you apply this to your policy? I would like to recommend a few topics on intellectual property that you may consider including in your collections management policy. Your museum's commitment to copyright research in the collection and legal obligations. Your museum's commitment to observing the rights of artists. Your intentions for documentations of use and research. How your museum deals with fair use applications in the museum. Who is responsible for researching intellectual property issues? And if your museum has one, a reference to your intellectual property rights policy. Here are some links and publications that I've used for developing my presentation that might be helpful for you when you're developing your policy. Thank you very much.
That was great, Laura. Thank you. You know, I found it really interesting, this is Robin again, that both you and Tina mentioned the whole thing about ownership doesn't necessarily include copyright. And that's something that I know I've had kind of drilled into my head, because originally when I first started working in museums over a decade now ago, I remember thinking, hey, well, we have this thing, we can put it in a catalog, we can do whatever we want with it, we have the deed of gift. And there is a definite difference between having that deed of gift and having the actual rights to your reproduction, especially if people want to start putting the things on t-shirts and putting them in the gift shops or on coffee mugs. So it's kind of a whole thing unto itself. The other good source that I wanted to pass along to everyone that they might find interesting is Anne Young published a book last year with AAM, I guess it was. It's called Rights and Reproduction Handbook by AAM. It's only like $5, the digital copy of it on the AAM bookstore. And Anne is really popular and active on Twitter. So if you ever want to ask her a question, she's at A Young R&R. She'll answer you right away. I've known her through some Twitter chats. I've met her at AAM, and she's really nice, and she's actually in school to become a lawyer right now. So she's a good person to ask if you have a really sticky question on those kind of things. So now I'm going to go ahead and ask if our friends down in South Florida have any questions for the group, or for Tina, or for Laura.
No questions, thank you.
Great, thanks. Are there any questions up there in Tallahassee for Tina or for Laura?
No questions.
Great, and I'm going to look around the table here in Bradenton. I think we'll always have questions on this subject. It's when it gets down to like the specific question, right? It's like, you have this thing and you're like, can I use it or whatnot? So having these resources and all that will be very useful for sure.